On 26 June 2025, President Hakainde Hichilema directed that Bill number 7 be deferred to allow for wider national consultations. Just a day later, on 27 June 2025, the Constitutional Court declared the amendment process unconstitutional, citing lack of broad public participation. When a point of order was later raised in Parliament to test the legality of the bill, Speaker of the National Assembly, Nelly Muti, ruled that Constitutional Amendment Bill number 7 of 2025 was properly before the House, insisting that once a bill is before Parliament, external bodies, including the courts, cannot stop it. The ruling sparked backlash, and the Law Association of Zambia sued the Speaker, arguing that her decision undermined the Constitutional Court's authority and violated constitutional supremacy. Now, with Parliament set to reopen in the coming days, Speaker Muti has once again stirred debate by noting that chiefs in Mutchinga province want the constitutional review process to continue, stressing that Parliament itself is ready to resume deliberations once the executive is given a go-ahead. Against this highly charged backdrop, my guest tonight is Celestine Mukandila, one of the petitioners who successfully challenged Bill number 7 before the Constitutional Court. We discussed the bill, the ruling, the Speaker's decision, and the lawsuit, the political implications, and what the next steps should be for Zambia's constitutional reform process. Good evening once again. Welcome to Costa. My guest is Celestine Mukandila, a Lusaka-based lawyer. We discussed Bill 7 and what the way forward is for Zambia's constitutional reform process. Counsel, good evening. Thank you so much for joining us on Costa tonight.
Good evening, Mr. Mwansa, and thank you very much for having me here. Good evening to the Zambian people.
I would like for us to start with the comments that are coming through from the Speaker of the National Assembly. He was touring different constituencies the past few weeks. And one of the things that he said is that chiefs in Mutchinga province want Bill 7 back in Parliament, and her response was that Parliament is ready to deliberate on Bill 7 once the executive gives Parliament a go-ahead. I'd like for us to begin off, from there, and what you make of the sentiments from the Speaker of the National Assembly.
Well, you see, Andrew, I was extremely disappointed by the statement of the Speaker, disappointed that we have individuals occupying honorable offices who decide to reduce themselves to levels of being mere political cadres. Disappointed that we, as a Zambian people, have got a Speaker of the National Assembly whose role in the National Assembly is to head the legislative arm of government, and apart from that, she has to be a mediator or an umpire, more like, when it comes to parliamentary processes. Disappointed that we have a Speaker of the National Assembly who appears not to understand the fact that the National Assembly, or indeed the office of Speaker of the National Assembly, is a creation of the Constitution of the Republic of Zambia. Why do I say she appears not to understand that? And very disappointed, perhaps also, by virtue of the fact that this Speaker is not only a lawyer, but she's a woman of silk. She's of State Council. And not only that, she is Speaker of the National Assembly. Now, the constituent authority of a Speaker emanates from the Constitution of the Republic of Zambia. The Constitution of the Republic of Zambia, under Article 128, has actually provided for the creature or the creation of and the jurisdiction of the Constitutional Court. Now, I want you to understand this. This Constitution we're looking at, which is Act number 2 of 2016, Constitution of Zambia, Act number 2 of 2016, has provided, perhaps under Article 1, that Constitution or this Constitution is a supreme law of the land. you know. So this constitution is the supreme law of the land. By virtue of the fact that it's the supreme law of the land, any law or authority or decision or act or omission that is done in contravention of provisions of the constitution, such laws will be declared a nullity to the extent of its inconsistency. Now, when you look at Article 128, which creates the Constitutional Court, it also indicates that the Constitutional Court is a court of original jurisdiction, and it does not have any appellate court from the Constitutional Court. It's a court of original jurisdiction and final jurisdiction when it comes to matters that are given. Now, the only court in Zambia that has got authority, or should I say the only body in Zambia that has got authority to interpret this constitution we're talking about, which is Act number 2, is the Constitutional Court of the Republic of Zambia. Now, the Constitutional Court, in the case of Munir Zulu versus Celestine Mukandila, in our case, actually gave a judgment. In the judgment of the Constitutional Court, the court ruled, amongst other things, if I may refer to J25, page J25 of the judgment, where the court said, accordingly, we grant the following relief. We declare that the decision of the respondent to initiate a constitution amendment process before undertaking wide consultations with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92 of the Constitution. The further order that the court gave was that we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultation with the people. Now, having been given a judgment by the Constitutional Court, I want the Zambian people to hear me very clearly. Having been given a judgment by the Constitutional Court, there is no appellate process. This is the final position as to how you can come up with a constitution, or as to how you can alter a constitution of the Republic of Zambia. And because it's a final position, the Constitutional Court has actually indicated that about 9 provisions of the Constitution were breached by the respondent when they were coming up with the bill. Now, in this instance, it simply means that Bill 7 remains unconstitutional, and the court has directed that the process of coming up with a bill should be that which represents the wider majority of Zambian citizens through a people-driven constitution where an independent body of experts is going to be instituted. Now, you have on one end a declaration by the court, a court which is a constitutional creation or creature. On the other end, you've got a Speaker of the National Assembly who decides to make a statement that purports, in fact, it is apparent that she is going to go against the provisions of the Constitution. Now, why do I feel so disappointed? It is because the primary role or the primary duty of counsel or of a lawyer is a duty that is owed to the court. We owe a duty to the court, and the duty we owe to the court is an inherent duty, never differentiated, or it can never be taken away. So we owe the court an inherent duty, and that is why when there's a ruling like this or a judgment, whether I was against the judgment or I was for the judgment, I will have to respect the judgment at all costs. Now, the argument this speaker decided to put on the table was that...
So before we can get to the argument, my question was on the sentiments that she made, that the chiefs are the ones that are saying that they want Bill 7, back in Parliament.
I'll actually indicate that it's very appreciated that the chiefs, our parents, are indicating that they want Bill 7 in Parliament. We appreciate that. However, it is extremely unfortunate that Zambia is a constitutional democracy. Because we're a democratic state, a democracy that will have to respect the rule of law, a democracy that will have to respect separation of powers, the Constitutional Court has ruled. Unfortunately, Bill 7 is no more. It's a dead bill.
The position of the Speaker was, the Speaker ruled, on that point of order that Bill 7 is properly before Parliament and cannot be stopped by the courts. And I want to see how you respond, to the interpretation of legislative independence. Doesn't Parliament have got legislative independence to make laws? We respect the jurisdiction of the courts also to interpret what these laws,
You see, Andrew, when we were coming up with this action, I will tell you something. We sat down with council and discussed at length, and we agreed that, listen, we have precedent where the Law Association of Zambia took on the AG to interpret as to the provisions of to whether you can stop a bill from being enacted in the National Assembly. But the position of the law, as guided by the Constitutional Court, is that you cannot stop the National Assembly from legislating. However, we looked at the scenario and said, no, but the decision to come up with a bill is an executive decision. And we must be able to now find out from the court whether the process that the executive arm undertook to amend this constitution or to come up with a bill is a correct process. That is where now our contention was. We do not dispute that the National Assembly has got an inherent authority to come up with laws or to enact legislation. The courts have already guided. And why do we feel we must respect that position? It is because the courts have guided us, and we must respect the court's orders and the court's judgment. But in this case, we're looking at a scenario where we were challenging the bill and how the bill came about, not the process of enactment. You get it? Now, if the Constitutional Court decides to tell the Zambian people that this bill and how it came about is actually one that did not live up to the spirit of this constitution. When you look at, for example, I'll just try and refer to you to Article 90 of the Constitution, which gives the authority, which is executive authority, to the executive. So the principle of executive authority, Article 90 will say that the executive authority derives from the Zambian people. You get it, huh? And shall be exercised in a manner compatible with the principles of social justice and the people's well-being and benefit. Now, when you look at the fact that this executive authority is vested in the presidency, when you look at Article 91, and the executive authority should be exercised in such a way that it promotes the protection of this constitution and it upholds the rule of law. Now, the executive authority that was exerted on the process of coming up with this bill, where the minister decided to announce on behalf of the president, by the way, is one that emanates from Article 90. So because of that, as long as you decide to come up with an act that is unconstitutional, as has been guided by the courts, that law is repugnant and it has to be declared a nullity to the extent of its inconsistency. You get it? So in this case,
so even
Bill 7...
Even when the bill is already in motion before Parliament...
It doesn't matter. You see...
Because what I'm getting is that what the judgment was based off the pre-legislative process, that the pre-legislative process was not correct.
Exactly.
But then the bill is already in motion in Parliament. Does the courts have powers to stop a bill in motion?
Andrew, the reality is, what is tabled before the National Assembly today is an illegal, unconstitutional bill. An unconstitutional bill. And I don't feel this speaker, who is sworn in to protect and defend the Constitution of the Republic of Zambia, should decide to table a bill that is unconstitutional. Remember, we've got a constitution that guides whatever operations we do. This constitution will tell you that whatever it is that you do will need to be in accordance with the provisions of the constitution. I'll actually tell you that the statement the Speaker made actually clearly shows that this Speaker of the National Assembly is a constitutional delinquent. And I will prove it. You cannot table anything that is unconstitutional before the National Assembly. Neither can you deal with anything that is unconstitutional. The moment the National Assembly the moment the courts gave an order to indicate that the process will need to revert, the process of coming up with a constitution will need to commence from a point of having instituted a commission of inquiry, as was the case when coming up with the previous commission, when coming up with Act number 2 of 2016, this constitution that we're using. The courts guided actually. And if I may just read a portion of the judgment so that you understand the reasoning of the court. I think it's important that this Speaker may be reminded that she's a constitutional office bearer and she has to protect and defend the Constitution at all costs. The court, in our case, indicated on page J23 that in our considered view, the TCDZC process, which is the Technical Committee on Drafting the Zambian Constitution process, should be replicated or something of a similar magnitude pursued in initiating constitutional amendments. It constitutes what we understand to be the wide consultative process necessary to alter the existing content of the Constitution. State actors should be facilitators of the people-driven Constitution or people-driven process led by an independent committee of experts. And it goes on to say, which should collect views directly from the people and existing records of submissions by the people. Only after these proposals are put to the people in a structured manner, such as through district, provinces, and national level discussions, and adoption can be put through the process in Article 79 of the Constitution. The court went on to clarify, in fact, because the court knew that there will be individuals like this Speaker that we have, the court went on to clarify by saying, as the custodian of the Constitution, we take cognizance of the importance of our decision in this matter, as it is critical for protecting the Constitution in its current form and spirit. As the fulcrum of the legal system, the Constitution is not only expected to stand the test of time, but enjoy the legality, legitimacy, and trust needed to ensure it's acceptable. Now, the Constitutional Court actually knew that we'll have individuals like this Speaker. But now, I'll actually tell you that, for me, if this Speaker decides, as she made that statement, in fact, that statement to me, as a Speaker of Council, she's a lawyer, that statement actually flies in the teeth of professional misconduct of lawyers. It also abrogates constitutional provisions. It goes against the spirit of the oath of office that this Speaker saw in to protect and defend the Constitution. If anything, that professional misconduct, Laz should actually take action. I saw Laz writing to this Speaker, indicating or reminding her that there are matters before court dealing with the bill. And not only that, reminding the Speaker that that bill was actually declared unconstitutional. That is the direction we are heading to. But if this Speaker continues with this, I will tell you, Mr. Mwansa, that she doesn't deserve to be in that office.
We've seen not once, not twice, on several times where the Constitutional Court, has misapplied itself in interpreting, the Constitution. Just recently, the widely a case of Edgar Lungu and him being able to participate in the 2026 elections and future elections. We saw how the court misapplied itself and corrected itself. Don't you think this is a clear case of misapplying itself as well? Because other people argue that the Constitutional Court did overstep their jurisdiction by holding that wide public consultation must precede the initiation of any amendment process, and give an example before a bill is even drafted, which he said conflicts with the provisions on lawmaking and separation of powers, and this is in reference to Article 62, Part 2, 78, 79, 88, and 91. On grounds of challenging, this particular decision. And so others say that this is another case of the courts misapplying itself.
Unfortunately, Andrew, as long as the position of the Constitutional Court remains that those provisions that we indicated were breached and this bill is unconstitutional, as long as those provisions, as long as the judgment of the court remains as such, there's nothing we can do. There is totally nothing we can do unless the decision is challenged and the court gives its ruling per incuriam, if at all there was any misapplication or any misappropriation of the provisions of the Constitution by the court. But as it stands, the law remains that the process to undertake to amend this Constitution should be one that requires that you institute a committee of experts to collect views and come up with a bill. Period. Anything away from that defies the spirit of the Constitution. So, because I'm a lawyer and the Speaker of the National Assembly is a lawyer, our duty, our inherent duty is first to the court. She has to respect the court decision. Whether she likes it or not. If this speaker, by the way, Andrew, I'll actually tell you, just to touch on the comment on the ruling of the speaker over this same issue in the National Assembly.
Yeah.
Not to dwell much into the issue, but when the speaker actually made that decision, coming out as though she's trying to interpret the provisions of the Constitution, that in itself was the speaker deciding to create an appellate process away from the Constitutional Court. And she usurped the power of the Constitutional Court in interpreting the Constitution. She doesn't have that power. If this speaker wanted to have such powers, she would have pushed for an amendment to the Constitution so that she should have power to interpret the Constitution. Hers rests at reading the provisions of the Constitution and applying as guided by the Constitutional Court. Period. Kwamana. She cannot go any further to come up with her own interpretation. What did she even mean when she said, to me, I feel this is enough consultation? When you look at that ruling, but that was simply her creating herself into an appellate court from the Constitutional Court and giving herself powers that she does not have. This speaker does not have powers to interpret the Constitution. Article 28 is clear. 128 is clear. The only authority with the power to interpret provisions of this Constitution is the Constitutional Court. This speaker just has to follow what the Constitutional Court has guided. It's as pure as that. The ruling that she had given, which purported to show that she was trying to interpret provisions of the Constitution, was actually extremely illegal, unconstitutional, and it goes against the spirit of the Constitution of the Republic. So in short, this speaker, to me, I would actually say she's a constitutional delinquent. She has decided deliberately to abrogate provisions of the Constitution. And for me, I'll actually tell you.
Do you see a clear case of separation of powers? Because on the 26th of June, President Hakainde Hichilema did direct the Minister of Justice to defer the bill. On the 27th of June, your judgment came out that you won against this illegality that you called, and the Constitutional Court interpreted, in your favor. And the a clear case really of separation of powers, and that not at any point do these three, arms of government are getting to meet. They're not getting to meet at any point because the Constitutional Court has given the courts have given a clear position. The executive arm of government, which is the president, the head, has given a position. The legislative authority, which is headed by the Speaker, has equally given a position. Don't you see a clear case of separation of powers? That there's respect for this separation of powers?
My brother, I'll tell you that the deferment of the bill by the president, or the direction to the minister to defer the bill, remains an academic exercise, especially after the ruling or the judgment of the Constitutional Court. Remember the judgment. Maybe let me read it for clarity's sake, for the Zambian people to be reminded of what this court indicated. Let me read it again. In short, what the court was trying to say is that bill, 11Co, forget about it. It's neither here nor there. It's illegal, it's unconstitutional. Just the coming up of that bill was a breach. So this constitution, the court, in its judgment, on page J25 of the judgment, said, as I quote, accordingly we grant the following relief. 1, it said, we declare that the decision by the respondent to initiate a constitutional amendment process before undertaking wide consultation with the people goes against the spirit of these articles, about 9 articles of the Constitution. So it simply means that the process of initiating that bill, we have declared that it was unconstitutional and it goes against these provisions. In short, we have declared that the president and his minister, or through his minister, breached the provisions of the Constitution. The president breached the following provisions: Article 1, Article 2, Article 5, Article 7, Article 8, et al. So, that is one thing we need to understand. There was a breach. The second order, the second relief that the court gave or granted us is that we order that the respondent, now I want you to understand, the respondent in this case is the Attorney General. The Attorney General representing the Minister of Justice as well as the President of the Republic of Zambia, President Hakainde Hichilema. So it says, we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. There is no independent body of experts that has been instituted yet. And therefore, there is no amendment process that has commenced. That deferment remains an academic exercise. If this president will continue with the process of enactment, if this minister will in fact not go and inform the National Assembly by the 13th that she is withdrawing that bill, she will be held in contempt. We don't have a problem with commencing those proceedings. No problem whatsoever. And this minister, together with the Speaker of the National Assembly, will be held in contempt. Now, if I may be academic to some extent, so as to educate the Zambian people, what really it entails to have that concept of separation of powers. The concept of separation of powers, as propounded by one individual called Montesquieu, indicated that this is a democratic or good governance concept, which entails that arms of government will operate on different wavelengths to separate their operations. In short, they must operate independent of other arms. Now, this simply entails that the reason why this concept or process or rule was brought about is to ensure that none of these would be allowed to go beyond the authority that is granted to them. Now, remember, this is so as to ensure that there is checks and balances on the different arms of government. Now, the different arms of government that we have includes the executive arm, the legislature, and the judiciary, the judicature. Now, when you look at these arms, they provide a model of checks and balances on themselves. The checks and balances that we undertook when it came to this Bill 7 was to go to court, request the court for an interpretation as to what or how the executive authority was exercised by the executive arm. And the court checked the executive authority that was exercised and indicated that it was illegal. It was unconstitutional. It breached the spirit of the Constitution. Simply put, there was a breach. So this arm of government, now, because of the concept of separation of powers, has come to stop the executive arm as well as the legislative arm. Now remember, Zambia is a democratic state which is a constitutional democracy. Whatever we do must be in line with the provisions of the Constitution. In the leadership of this country, now provisions of the Constitution will tell you that when you are making a decision, that decision must be in tandem with the provisions of the Constitution. If it goes beyond that, that decision is declared ultra vires the powers that is granted to them or to the authority. So that is where we are. As long as this constitutional court declared that that decision to come up with Bill 7 was illegal, and the Constitutional Court went further to give guidance as to how we must undertake certain processes and procedures in order to amend the Constitution of the Republic of Zambia. Amongst them includes that an independent body of experts must be instituted so as to ensure they collect views from the people for the sake of consultation, broad-based consultation, wide consultation. That is a guidance from the Constitutional Court. Now, I'll actually tell you, Mr. Mwansa, that this Constitution, and the Zambian people must know, by virtue of the fact that there was a proclamation of the Constitutional Court, that the actions of the respondent went against the spirit of 9 provisions. Yeah. It simply means that there was a breach of the Constitution by the president. And that is actually impeachable. So this president should wait for his time to actually be impeached. It's only that currently, I will actually tell you that this speaker is a traitor to the national democracy of this country. This speaker has decided to show the Zambian people that she's a traitor to the Constitution of the Republic of Zambia. This speaker has shown the Zambian people that she's actually not supposed to be even called honorable, because she has made a statement which is dishonorable where we are. Even the statement she made is actually impeachable. We must look at provisions of Article 83 of the Constitution of the Republic of Zambia, which in fact, if we have to look at the provisions of Article 83, I think these are provisions that deal with the impeachment of the Speaker of the National Assembly. She has gone against the provision of the Constitution. The Constitutional Court has already guided. That bill goes against the spirit of the Constitution. Why should you entertain it? So if this Speaker is not in fact even the first one to initiate the impeachment process of this president.
So she misapplied the interpretation of...
She's not even supposed to interpret the Constitution. She doesn't have jurisdiction. That jurisdiction is a preserve of the Constitutional Court. The Speaker is just supposed to apply what she's guided by the Constitutional Court. What she should have done is to stick to the standing orders. You will read the standing orders vis-a-vis the provisions of the Constitution quite okay. But where you feel as Speaker that you cannot understand or you have not understood the provisions of that Constitution, this Speaker ought to have taken that provision for interpretation before the Constitutional Court.
Doesn't she have authority over what happens before Parliament?
Mr. Mwansa, I want you to understand this. It's extremely important to understand. Very important. The Speaker of the National Assembly has got a role. Her role to play in the National Assembly, to preside over affairs of the National Assembly, to ensure that she's more like an umpire on the operation, on the debate, which includes everything, to ensure that she even conducts the business of the National Assembly when coming up with the bills. She's the head of the legislator. And apart from that, she's one that will have to do her job in line with the standing orders. And now, because the authority, the constituent authority of the Speaker emanates from the Constitution, remember this Constitution is the people's document. So her authority comes from the people. The constituent authority comes from the Constitution. For the Speaker, she has to do everything in line with the provisions of the Constitution. She's a Constitution office holder. This Speaker saw in to protect and defend the Constitution of the Republic of Zambia. Apart from the fact that there is an act of an oath of allegiance to the President of the Republic, there is also an oath of office, an oath that requires that you shall defend and protect the Constitution of the Republic of Zambia. Now, let me just take you to that article, Article 83, which provides for removal of the Speaker of the National Assembly. If the Speaker of the National Assembly, Article 83(1), A actually says where the Speaker or Deputy Speaker violated this Constitution. For me, I'll actually tell you that it is a violation of this Constitution if the Speaker made that statement. In fact, when the Speaker made that statement, she violated this Constitution. She equally deserves to be impeached, as a matter of fact. And it only requires 1/3 majority of members of Parliament. Now, I will actually remind my members of Parliament in the National Assembly that the Constitution is extremely clear. Our colleagues, when taking up office in the National Assembly, equally took an oath to defend and protect the Constitution of the Republic. Mr. Mwansa, and the Zambian people should bear me witness, any person in that National Assembly who will decide not to back up a notice of motion to impeach this president or this speaker will be a traitor, and it must be on record that that person should be considered a traitor to national democracy and a traitor to the Constitution of Zambia and a traitor to the Zambian people. That person should not even be called an honorable member of Parliament, because you will have gone against the provisions of the Constitution. And the Constitution is very clear. The Constitutional Court told us that the executive arm went against the spirit of the Constitution. 9 provisions, Mr. Mwansa, not one, 9 provisions of the Constitution were breached by the executive arm. And any breach, the Constitution is very clear, any breach to the provisions of the Constitution will result into an action being taken. And this action, for example, for the president, we're looking at impeachment. You cannot have a president that is at the epic of the running of the country on top of abrogating the constitutional provisions. And by the way, Article 2 of the Constitution of the Republic of Zambia, which is Act number 2 of 2016, Mr. Mwansa, provides for the defense of this constitution. Now, let me read it so that the Zambian people should know that what we are doing here is has got nothing to do with politics. This has got everything to do with the duty that I have as Celestine Mukandila to defend and protect the constitutional provisions and the Constitution of the Republic of Zambia. And I've put it on record that I shall do so even if it meant doing so with my life, because I've got a duty. Now, Article 2 says every person has a right and duty to defend this Constitution. Every person has a right and duty to defend this Constitution and resist or prevent a person from overthrowing, superseding, suspending, or illegally abrogating this Constitution. Now, I will tell you, Mr. Mwansa, this duty is not mine alone. This provision gives you, sir, the right and duty to defend this Constitution. This Constitution was abrogated by this president. And it is clear, the Constitutional Court has told us 9 provisions, sir, were abrogated. So you and me, we've got a duty to ensure that we follow what Article 2b says. Resist or prevent a person from overthrowing, suspending, or illegally abrogating this Constitution. So, sir, we've got a duty. This duty we owe to ourselves, and we also owe to these Zambian people that are watching this, to ensure that we stop President Hakainde from proceeding with abrogating the constitution in the manner that he did. So now those that are in the National Assembly today have got a duty, this same duty. And if they don't adhere to this duty and vote with everyone else on the notice of motion, one, to impeach, and just to ensure that they, in fact, even bring the notice of motion to impeach.
Is that what you're pushing for? That
Mr. Mwansa, I will tell you
to impeach the president.
Mr. Mwansa, I will tell you that we are even late. By now, the Zambian people, the National Assembly Speaker, the Speaker of the National Assembly, should have had a move to move the motion herself as a member of parliament to impeach this president following the ruling or the judgment of the Constitutional Court. She should have done that. And I will tell you that the integrity of that office would have risen to levels that she's a defender of democracy and constitutionalism. Look at what Nancy Pelosi did in the US. Nancy Pelosi is the speaker who moved the motion to impeach in defense of democracy. And I will tell you, Andrew, today this speaker has failed to live up to her oath of office. Members of parliament today have failed the Zambian people right now to live up to the spirit of the constitution by raising or initiating this notice of motion to impeach this president. This president must be impeached. We cannot have anyone, a person occupying the highest noble office of the country, abrogating the constitution, and we must sit and watch. I think over my dead body, Mr. Mwansa, I will not stop talking about constitutional provisions that are breached, because I've got two oaths that I saw in, by the way, as counsel, as a lawyer. One, the oath of office to protect and defend this constitution. The other one is the oath of allegiance to the Republican president. And I will tell you that the reason why I'm talking about this is because the office of presidency today is occupied by a constitutional delinquent, a person who decides to abrogate the constitution of Zambia according to the Constitutional Court. We've been guided, and the Zambian people have seen. We have a president that abrogated the provisions of the constitution. This president saw in to protect. I think you need to look at the oath of office that he took at Hero Stadium. He said he shall diligently execute functions of that office and protect and defend the provisions of the Constitution. It is clear there are breaches, and these breaches require that corrective actions are taken. Now, you see, Mr. Mwansa, we are not dealing with a breach of just a mere act of parliament. No. We are dealing with a breach of the grand norm, the instrument that creates Zambia, the constitution.
So this push of a motion that you are trying to push for, will it happen when Parliament reopens on the 13th, or perhaps you will push for that motion if the minister decides to bring back the bill in Parliament? Because at the moment the bill has been deferred. Deferment does not mean withdraw.
Bwana, listen, I want you to understand me and quote me very correctly. There was a breach. Currently, as we are, as the Zambian people are seeing, the Constitutional Court has already pronounced a breach of 9 provisions. The Constitutional Court has pronounced a breach by this president, by this executive arm. The executive authority exercised by the president through the minister to come up with this bill was a breach of the Constitution. It was unlawful. So you shouldn't even ask me whether I will only decide to push for the impeachment to come about when the bill continues. No. This is the will in motion. It should have, in fact, we are late as a Zambian people. I'll actually tell you that upon receiving my judgment from the Constitutional Court, I told myself to say, okay, there was gross misconduct that was occasioned by this government and by this president, because this president decided to abandon the oath of office. Now, the Official Oaths Act chapter 5 of the laws of Zambia is very clear. It is very clear. Let me just read what it says. It mandates that a person assuming the office of president shall take and subscribe the oath of president as set out in the first schedule, and the oath shall be administered by the Chief Justice. Now, this president undertook an oath of office. And this oath of office, when you watch the inauguration process, he lifted his Bible and read that I, Hakainde Hichilema, shall defend and protect the Constitution. We are late, Mr. Mwansa. I expected, for me, I'll tell you, I expected that members of parliament, in their own volition, would move the notice of motion to impeach on their own, without me reminding them that they have a duty to protect and defend the Constitution. I expected that to be done. In fact, I expected that this speaker would be the first to even move that notice of motion. Why? Because she's received a lot of awards out there internationally as one of the best speakers in the country, because she's a female speaker.
Under Article 107 of the Zambian Constitution, it clearly provides, for the removal of the office of the president. It says that if the president is unable to perform the functions of their office due to physical or mental incapacity, number 2, or guilty of serious misconduct, including violation of the Constitution that you spoke to, gross misconduct or behavior, treason or other serious crimes. And it also provides for the procedure of impeachment. The National Assembly is responsible for initiating the impeachment. Steps are, number 1, the notice of motion. At least 1/3 of all members of parliament must submit a motion to the speaker requesting the removal of the president. Don't you think what you're calling for is purely academic? Because the president, who comes from the ruling United Party for National Development, their members of parliament constitute the majority of those that are in the House. Do you think UPND members of parliament would buy into your idea of going ahead to impeach the president?
Mr. Mwansa, I once indicated...
Where are the numbers going to come from?
Mr. Mwansa, I once indicated that UPND MPs actually received about 45 plus text messages from UPND MPs congratulating me for having succeeded in blocking Bill 7. And it was clear. You heard the recording by Chavinga and Honorable Minister, where he outrightly indicated to say, Nivambiri, a lot of ministers actually, and a lot of MPs did not support that. You heard that on your own. It's not me who manufactured that, but I told you that I received messages of people telling me that we are happy that you've blocked Bill 7 because it was unconstitutional. But I'll also tell you that as long as these MPs were voted in by the people of the Republic of Zambia, and as long as these MPs saw in to protect and defend the Constitution of the Republic of Zambia, they did not swear in to defend the legalities of President Hakainde. No. They were sworn in to protect and defend the Constitution of the Republic of Zambia. My brother, if they do not vote to impeach, where there is an instruction from the Constitutional Court that there were 9 provisions that were abrogated, if they do not vote to impeach this president, I will tell you that all of them will be considered traitors to this nation. Because we gave ourselves unto this constitution. They will be considered as sellouts to this nation. They will be considered as abrogators to the constitution.
How serious are these breaches that must amount to the president being impeached?
My brother, the constitution is very clear. Any breach occasioned... Just read the second part of that provision you are from reading. So that the Zambian people, for the sake of the Zambian people, the second part which says...
A president may be removed from office if they are guilty of serious misconduct, including violation of the Constitution, gross misconduct, or misbehavior, treason, or other serious crime.
Just there. If they're guilty of a violation of the Constitution, a violation. Here, the court has told us that the way this Bill 7 was come about does not live up to the spirit of the Constitution. 9 provisions were violated Mr. Mwansa. They were violated. It is as clear as that. A violation of the Constitution requires that this president must be impeached. Now, if this president is not impeached, and people decide in that National Assembly not to vote to impeach this president, I will tell you that the Zambian people must consider them, all of them that will not vote, to be traitors, and they don't deserve to be called honorable. They are called honorable members of parliament because they should honorably execute the duties and functions of members of parliament. Now, if any honorable member of parliament today should honorably execute his functions, his or her functions in that house, they should ensure that it lives up to the expectation of the oath of office that they took to protect and defend the Constitution. They don't vote. Zambians should consider these individuals as traitors. They must consider them as those that do not respect the Constitution. They don't deserve to be leaders. Because Zambia is a creature of the Constitution of the Republic of Zambia.
The beauty of that ruling that you got from the Constitutional Court is that it gives proper guidance of how constitutional amendments must go. If we follow those guidance that the Constitutional Court has given unto us, where we institute, an independent body to conduct, these consultations and all those things that it has set up, do you then support the animal Bill 7? If once those things that the Constitutional Court has provided for are done? Because what we must also take note here, Council, is that Bill 7 has not been withdrawn, it's just been deferred. And chances are that it could be brought back.
And we've indicated.
And that's what your argument is, that it can't be brought back because the Constitutional Court has stopped it from happening before these things are done.
You can't pretend over an illegality.
So what must be done, now that there's this Constitutional Court judgment that has come our way? What must be done, for the future of Bill 7?
Mr. Mwansa, I'll actually tell you that forget about Bill 7. Bill 7 is neither here nor there because it's gone.
It's just been defeated.
It's an illegal document. It's an unconstitutional document, according to the court. Now, maybe the question should be rephrased to say, what must be done with regards to the future of constitutional amendment in this country? What must be done is as guided by the Constitutional Court. The president has got the mandate or the right or the power to institute a commission of inquiry using the Inquiries Act, a technical committee of experts that is going to get views from the Zambian people and ensure that the Zambian people should propose what it is that they want to be amended. If it were up to me, Mr. Mwansa, I will tell you that a very progressive provision that should actually be proposed to be amended in this constitution should be a provision that requires that the president should be the one to propose the name of who should be Speaker of the National Assembly, one. A provision that deals with the president being the one to appoint the Chief Justice, two. If these provisions would be proposed, I will tell you that I will be the happiest person because we'll be reducing the powers of the president. We must gravitate to a level where we have a president, a responsible president, that is going to propose that, please, colleagues, let's reduce my powers. I've got so much power as president because I appoint and disappoint. Now, this constitution will tell you that the power to appoint comes with it the power to disappoint. That's what the Constitution says. So if the president is going to propose a name of a person to be speaker, then he's going to also propose that this person should be removed. If the president is going to appoint a chief justice, who's the other leader of the other arm of government, then he's going to have the power to disappoint this chief justice. Now, what I'm trying to say is the Constitution of Zambia as it is currently, in its current form and stature, according to me, my opinion, by the way, I don't feel it even requires any refining. I don't feel it even requires any amendment. Those provisions these colleagues are providing, are trying to propose, are even misguided. You want to propose a provision that deals with ministers leaving office, when the reality is that the Constitutional Court has already guided as to what it means. You want to provide a provision that deals with a certainty as to what it means to hold an election petition hearing when the Constitutional Court has already guided. If anyone, including President Hakainde, feels that there are certain provisions in the Constitution that have got lacunas, what they must do is to subject those provisions before the Constitutional Court for interpretation in accordance with Article 128 of the Constitution of Zambia. There's nothing wrong with doing that. There's no lion that is alive at the Constitutional Court that will stop you from taking a provision of the Constitution for interpretation. There's no lion there. So what they should do is, if they feel there are provisions that require refining, let them subject those provisions before the Constitutional Court for interpretation until such a time when the Constitution of Zambia or the Constitutional Court gives a guidance and we feel we cannot deal with certain provisions and we need to refine and add provisions. Then can we look at provisions that will amend the Constitution? And for me, I would actually propose, if anyone was to come to me to say, what provisions would you want to see in the national constitution? I would propose that let's look at provisions that, one, will provide for recalling a president who is going to be a delinquent. A party in government should be able to recall that president because they will have breached the constitution. Look at the case of Jacob Zuma and should be the Attorney General, where Jacob Zuma was recalled for having breached the provisions of the Constitution. We should have a provision of the Constitution that will provide that this president's powers are reduced when it comes to appointment of certain office bearers. The DPP should not be appointed by the president, because all these appointments that are being done by the president compromise the integrity of the independence of these arms of government. So now we've got a scenario or a situation where it appears as though there is a sync between the executive arm and the legislative arm, where the speaker is speaking the language of these politicians, when the speaker is supposed to be professional in her own right as a speaker. Where she wants to go and start talking because the chief has told you this, you, according to you, say, no, because the chiefs have said this, I will speak the language of the chiefs. No, but chief, in fact, we are ready to. You are not ready for anything, Madam Speaker. Madam Speaker is not ready for anything. Madam Speaker should only be ready to follow the provisions of the Constitution.
But she puts a condition that if the executive arm of government gives a go-ahead, then she'll preside over.
It should never be. That's why we're missing it. And the Zambian people should know this. As long as the court indicated that Bill 7 is unconstitutional, it shouldn't even be in the face of the speaker. Because her role and her duty is to protect and defend the Constitution of the Republic. So, if there's a provision or anything that is unconstitutional before her, she must be able to speak out and say, colleagues, we've been guided. This is unconstitutional. The very way that this speaker is being... we go to court because we're trying to seek for redress. We're trying to seek for answers. We go to court because the court will give orders that should be respected by everyone. The Constitution is very clear as to what it means when a court ruling is given. And when a Supreme Court or a Constitutional Court ruling is given, you must respect the provisions or the judgment of the court.
There's a majority judgment and there's a minority, judgment in that particular, case that you took to the Constitutional Court. Where is the constitutional breach if the speaker? Well, yes, she must respect, the judgment of the Constitutional Court, because then it becomes law. But if she's got a different interpretation of what,
it's not for her to interpret the Constitution. For her, she has to follow what the court said.
If she agrees with the minority ruling,
it's not. Here's the thing,
just like you have not agreed with all the
Mr. Mwansa, let me tell you.
But yet you respect, the
I don't have an option. If, for example, we've got a very funny judgment of the Constitutional Court dealing with the eligibility of President Lungu, for example. I did not agree with that judgment, but I don't have any right to not apply the judgment. Whether I agree with it or not, it is my duty to follow the judgment. Whether I like it or not, if I want I should go to heaven or hell, I have to respect the ruling or the judgment of the Constitutional Court. More so that on top of that, I am of counsel. As a lawyer, I should not be seen to go against the judgment of the court. I can give a different view, but it is law. There is no appeal to whatever is given by the Constitutional Court. It is law. So this Madam Speaker should not even entertain anything to do with that document, which the Constitutional Court has clearly spelled out to say it's unconstitutional. It's as clear as that, Mr. Mwansa. And the Zambian people should know there is a breach. The breach must be corrected. How do we do it? He who ensured that this breach was occasioned
and must be corrected by the executive arm of government.
By the Zambian people.
The Speaker presides over the business of Parliament and not to stop anything from happening within Parliament. And so if the bill is brought by the executive arm of government, what role then does the Speaker play, in this? Because then don't you think then if she goes ahead to stop the bill, then she's interpreting...
she's just following what the courts indicated. The interpretation has been given by the court to say this is illegal, it's unconstitutional. Bwana, what has to be done when coming up with a bill is, especially a bill to do with an amendment to the Constitution, is as guided by the court. Therefore, that did not live up to the spirit of the Constitution. Because she's faced with a document that does not live up to the spirit of the Constitution, she must withdraw that document on her own accord. She's not even supposed to be reminded by anyone. She's got a duty to follow the provisions of the Constitution. So now you see, we've reached a point where now in this country, freedom has been replaced by fear. Freedom has been replaced by fear. The Zambian people are not talking. This year, Article 2 tells us that we should not let anyone abrogate the provisions of the Constitution. Article 2 of the Constitution, Mr. Mwansa, you and I have read this provision, and I want you to take it upon yourself to go and tell President Hakainde, if you can even schedule an appointment or an interview, go and tell him to say, Mr. President, the Constitutional Court said this. Maybe your legal advisors, who includes the Attorney General and the legal advisor to the President, have not told him the truth as to the implications of the judgment of the Constitutional Court. Maybe he has to be told by a person like me, because I owe allegiance to this President. Now, my allegiance is that I should ensure that the President does the correct thing. If he makes a mistake in any way, I will tell him to say, Mr. President, there is a breach here. The same way that I'm talking to say, Mr. President, you made to be occasioned a breach of the Constitution of about 9 provisions of the Constitution. And therefore, it is only right that by your own accord, on moral grounds, you must resign.
As we conclude, with Parliament reopening soon, if Bill 7 re-emerges, will you return to court or mobilize civic action?
I do not expect Bill 7 to return to the National Assembly. That is very clear. And I expect that the correct thing should be done by responsible leadership. Now, responsible leadership is one that will be reminded that they are voted into power and they are sworn in to protect and defend the Constitution. The very Constitution that gave an interpretation. Now, we shall have no problem with instituting contempt of court proceedings against the minister. She doesn't have immunity, and I can assure you, the law will visit her. The courts will tell her to say, Bwana, we told you that this is illegal. Why are you pushing it? We'll ensure that we commence contempt of court proceedings, and we'll ensure that as we are doing that, we even request that a bench warrant should be issued, because that is a clear insult to the court. Now, apart from that, this speaker will also have to face it. Now, I know for a fact that there is a demand letter that was written by Law Association of Zambia to the speaker as well as the Attorney General. I only hope that this Attorney General is going to advise his client correctly. His client being that the Speaker as well as the President. To say, Bwana, this is the provision of the court, the provision of the judgment of the court. And therefore, because of this, we cannot do this. Then it means they will be doing a service to the nation. Remember, even this Attorney General is sworn in to protect and defend the Constitution. The Attorney General is not only counsel, but he is also a man of silk. He's of state counsel. He should live above board, above mere lawyers. He should live above political authority. He should be able to execute duties in line with the Constitution, protection of this Constitution. Until such a time when we decide to suspend this Constitution, then they can decide to behave in any manner as they feel, as if it's an animal farm. No, we're not in an animal farm. The law has to be applied, and it has to be applied equitably. Every provision of the Constitution must be respected. Every provision. And it is my duty to do so. It is your duty, Mr. Mwansa, to do so. It is the Zambian people's duty to ensure that no one who abrogates or suspends or illegally violates the provisions of the Constitution is allowed to do so. We've got a duty to stop that. And this duty that we have starts now. We must ensure that we respect, protect the Constitution of the Republic of Zambia.
Lusaka-based lawyer Celestine Mukandila, thank you so much for making time to be a part of tonight's edition of Costa.
Thank you very much, Mr. Mwansa, and thanks very much to the Zambian people. And please, I beg of the Zambian people, we must ensure that we live up to the duty given to us by the Constitution to protect and defend this Constitution against violation.
Well, there you have it. We've been discussing Bill 7, Courts versus Parliament in Zambia's constitutional debate. Our guest has been Counsel Celestine Mukandila, who took and dragged the Zambian executive to court over the interpretation of Bill 7, and the courts did rule in his favor. Parliament reopens soon. Is Bill 7 going to come back to Parliament or not?